Morena, gentlemen. Welcome to another fantastic day of online learning. So today we're going to continue with the Disputes Tribunal. It started yesterday, but before we rip back into that, we're just going to review the model answers for yesterday's activity set, being task 7 on page 11 of the workbook. So if you can open up your answers from yesterday and do a bit of self-assessment. So Han will absolutely be able to get compensation for his food that perished in the refrigerator after it failed, because it's reasonably foreseeable that a consumer would have food in his fridge. And $200 worth of food is a fairly reasonable amount because it's reflective of what a reasonable consumer might have in their fridge at any one time. Number B, so Abdullah's freezer stopped working, and this caused his ice sculpture of himself to melt. It's not reasonably foreseeable that a freezer would have been storing expensive art. So I wouldn't think that Abdullah would be able to claim compensation for that expensive piece of art. Joe's hair straightener catching fire, and this leading him to run out of the house in a panic, and ultimately his house burns to the ground. The business who supplied the hair straightener would not be responsible for the damage to the entirety of the house, because it's been demonstrated that Joe did not minimize the damage from the fault. So Joe didn't take reasonable actions to reduce the impact of the hair straightener being on fire. Him running out of the house was not carrying out his own obligations and duties. So the business would be liable to contribute to some of the damage in the bathroom, but the whole house would be unreasonable. Robert's hair straightener catching fire and him unplugging it and throwing it in the bathtub and pouring water on it would mean that he has taken reasonable actions to minimize the damage from the fault. So Rawadi would be able to claim compensation for the replacement cost of the damage done in his bathroom. And now his use of the outdoor cleaner and him tripping over a few months later and breaking his expensive car, he would not be able to claim for the loss of the expensive acoustic guitar, because it's not reasonably foreseeable from the failure of the outdoor cleaner. So moving back into talking about the Disputes Tribunal. So we looked yesterday at the Disputes Tribunal being a relatively informal, quick and inexpensive way for disputes to be solved. Now the Disputes Tribunal will help consumers deal with issues relating from buying goods and services. And this is what we've been looking at with the CGA. If that business has failed to remedy the defect as required under the CGA, our consumer can go to the Disputes Tribunal to try and enforce the remedy. So that's where services are not completed with reasonable care and skill. There's goods that are not of acceptable quality, and also loss caused by misleading advertising. And we'll be talking a little bit about misleading advertising next week as we move to considering the final examinable topic in the course, and that being the Fair Trading Act. Car accidents and other vehicle issues absolutely can be solved at the Disputes Tribunal. So if there's an accident and there's a dispute over who should pay for what, the Disputes Tribunal can certainly help with that. And also, if someone borrows a vehicle or a car and they cause damage to it, the lender of the vehicle, the owner of the vehicle, can also go to the Disputes Tribunal if our borrower hasn't been willing to remedy the damage that they've caused or that's happened whilst they've borrowed it. Also, the Disputes Tribunal will help within a house or flatting situation. So for example, if we've got a set of neighbours and they have a bit of a dispute over putting in a new fence and who pays for it, or repairing an existing fence, the Disputes Tribunal can absolutely help our neighbours uh, solve their dispute, settle their issue. If a flatmate stops paying rent but continues staying at a property, the other flatmates are able to go to the disputes tribunal and are able to get some advice and a judgment to solve this issue. Tree roots. So absolutely, we love our trees in Auckland City, our wonderful, beautiful green city. But these trees can cause issues to some of our man-made structures, such as water pipes and driveways. And if you've got a especially big tree on our neighbouring property, its roots might spread over and do damage to the other neighbours' driveway and water pipes. And if the owner of the property that has the tree on it, i.e. the owner of the tree, does not want to compensate their neighbour for the damage caused to their driveway or water pipes, the disputes tribunal can help solve this issue as well. Business deals can also be helped with at the disputes tribunal. So if there's a dispute over a contract between businesses, that might also relate to the buying and selling of services, but of course we know the CGA applies to consumers only. This is for a business to business contract. Or we might also have a dispute amongst the business partners or shareholders over an agreement. And the disputes tribunal could come in and help these businesses out. As we know from our last lesson, disputes have got to be up to or less than $30,000. So the big business disputes over deals will be going to the district or high court for settlement. Issues that the disputes tribunal cannot help with. So renting disputes between landlords and tenants. So that's different than the flatmate situation, where flatmates are going to the disputes tribunal because another occupant, so it's an occupant to occupant of the household issue. Here it's the owner of the property versus the person who's contracted to take possession of the property and use it to live in, the tenant. If there's an issue between these two, they're actually going to go to a different tribunal, being the tenancy tribunal, to help settle disputes. So the disputes tribunal won't weigh in on those types of issues. So perhaps the landlord has breached the right of the tenant for peaceful enjoyment of their property. The tenant would be able to take the landlord to the tenancy tribunal and to claim for damages from the breach of their rights. Alternatively, the landlord could take the tenancy tribunal if it's the case that the tenant has stopped paying rent. Rates, taxes, social welfare benefits, or ACC payments. So this is all relating to that relationship between everyday citizens and the government and local government. So those disputes will be dealt with in the court and not at the disputes tribunal. Intellectual property. So we're talking about someone's ownership rights over a creation of the mind. So things like copyright protection over songs that an artist could have made, those or a patent that an inventor might have over a new invention, a new mechanical invention they've made. If there is an issue with someone abusing and misusing someone else's intellectual property, this will be something that the court will decide on as opposed to the disputes tribunal. Employment issues, so this is a dispute between a worker and a business. Those will be dealt with at the Employment Relations Authority. Wills, so we're talking here about how people have set out how their assets are to be distributed amongst their whānau and friends after they pass away, or perhaps they might be giving them to a charitable organisation. If there's a dispute over the will, that will be going to the court as opposed to the disputes tribunal. Issues over land, these also will be going to the court as opposed to our disputes tribunal. Family law issues, so relationship property, which you might be dealing with in terms of a separation, and joint and split care of children. Those would be going to court, family court, as opposed to the disputes tribunal. And when we have debts, but the person who owes the money actually agrees that they owe the money, so there's not a dispute over an amount owed, but the other person, the debtor, cannot pay the debt. So in that case, the disputes tribunal isn't required to weigh in on the issue because the debt is not disputed. It's just the ability of the indebted person to pay what they owe. So these issues are of a complex nature. So they're relating to very complex and difficult, very tricky areas of the law, which are best considered in a formal court where a judge, highly experienced, incredibly capable judge, will be helping decide on these matters, and also using lawyers to help present the legal arguments and defenses. So we've talked about lawyers being appropriate in more complex situations, and the disputes tribunal is one where it's been set up to be fast, inexpensive, and informal. So we would see these issues here that the disputes tribunal not dealing with as the ones that are much more appropriate for our lawyers to come in and present their complex legal arguments and defenses. And our final slide of the day, guys. So if you're making a claim to the disputes tribunal, your claim needs to be made within 6 years after the event that caused the dispute. If you cannot make your claim within 6 years, the applicant should go and talk to a lawyer, and hopefully they'll be able to give some good advice about some other avenues that the applicant might be able to take to try and get a remedy over a claim. You can make a claim by jumping online, and it's very easy to do. You just go to the following website, disputestribunal.gov.nz, and you can lodge your claim through that internet portal. Or you can do it the old school way. You can file a claim by paper by printing off a form that you find online, and then putting together your supporting documents to your claim and mailing them to the Ministry of Justice. Or you can submit these hard copies to the local district court in person. Both options, by the hard copy option, the online version, very simple ways that are meant to be accessible for your everyday person to help settle their disputes. As we talked about a little bit earlier on in this topic, the disputes tribunal is a relatively inexpensive way to solve disputes. However, there is a small or a modest fee that is charged when making a claim to the disputes tribunal, and the size of these fees depend on the value of the claim. And this is going to reflect that the more sizable the claim is, so if it's up towards that 30,000 mark, then the more time and more complex consideration will be likely needed to solve the dispute. And so the disputes tribunal will be seeking a slightly higher amount to reflect the greater difficulty and time that's likely to be needed to solve a more expensive claim. But that said, they're still very modest amounts at $45 if you're claiming for an amount less than $2,000, $90 if the claim is between $2,000 but less than $5,000, and $180 if your claim's between that $5,000 and $30,000. So certainly worth it from an applicant's point of view, being that the cost is far less than the sought amount. In any case, if you didn't get your claim as you'd hoped, it's still a modest amount. Today's activity, guys, is to complete task 8 on page 14 of the workbook. Just a reminder to my class, we've got a class Zoom meeting at 12:15 p.m. tomorrow, Friday. Any questions or issues, guys, please email your teacher. Kia kaha.